Judge, the state does oppose bond in this case. They've done enough bonds with me to know I follow a particular protocol when I go through my bonds. I always start with the case history. I'm talking about an incident date of February 20th of 2025. That is less than 12 months ago. An arrest date on this case was July 8th of 2025. This case went before the grand jury August 19th of 2025. We had a bond hearing on August 19th of 2025 as well, which I'm going to talk about in a minute. The trial court date on this case is set for August 3rd of this year, which is less than 1 calendar year from indictment.
Pause right there. Did you catch that? Less than 1 year from indictment to trial. In serious felony cases, especially ones involving malice murder, that is lightning speed. Courts move slowly by design. Discovery, motions, forensic analysis. It usually stretches on.
That is incredibly fast. Opposing counsel did mention the additional time based on the continuance that for all intents and purposes had to be granted. That is not a consideration for the court. The court's structure in regards to this is pretty straightforward. There is no material change in the circumstances of the defendant. That's where we are. I'm going to read from that bond order on August 19th of 2025. After hearing evidence presented regarding the defendant's motion for bond, this court finds the defendant is a risk to flee the jurisdiction, not appear for future court appearances. The defendant is a risk to influence witnesses. The defendant is a threat to the community and family members as testified to at defendant's hearing regarding bond. Through all of the testimony and argument we have heard today, there has been nothing to dispute that fact. If anything, I think it could be argued that the flight risk is actually more significant now than it was before. The family in this case does oppose bond, Judge, and one other thing that I do want to address is that was at the beginning of opposing counsel's argument. Our relationship with both sides is as much as we can make it. Miss Bruce, Mr. Nolan, and and DJ, the biological father of the defendant, they have been invited to our office constantly. Anytime we have spoken to the Brock side, we have reached out to the other side as well. They choose not to come. I sat down on that August 19th, 2025. We sat up in our brand new grand jury room up on the 5th floor, and I sat and answered their questions for at least a couple hours. I think it was about 2 hours that we were up there. They have been asked to come in every single time. I am inviting them to come into our office to talk to me today, tomorrow, any day, anytime. I cannot make this more clear. Anytime they want to come in and talk about the case, I am available to them. If they want to, we can set up a conference call on a weekend. If they need me to drive up to Marietta or up to Rome, I will drive up to Marietta or I will drive up to Rome. I drove up to Marietta a couple weeks ago with my investigator. Ms. Bruce was actually not there. So we have tried our very best to have a good relationship with them. They have turned their back because they do not believe that we are prosecuting the right person for this case. That was something I told them from the very beginning. I'm going to be as open and inviting as I can be, but we are not going to agree on that fact. They choose not to come in, Judge. I have conversations on the phone with Mr. Nolan and with Ms. Bruce because they live far away and it is difficult for them to come in. Any person in that family who wants to come in and talk to us can do so. At that meeting on August 19th, I told them to bring as many people as they want to. Friends, family, whoever they like. I invited them to record the interaction if they would like to.
Now we're shifting gears from procedural to emotional impact. And this is where bond hearings stop being technical and start being deeply human. When families speak in bond hearings, it's not about proving guilt. That's for trial. It's about risk, fear, safety.
I have no problem talking to them. The state is not scared of talking to the family on either side. We invite them. Going back to the Brock side of the family, Judge, I do have a statement from them. They oppose bond as well for the same reasons that they opposed bond in the first time. I would like to read this statement from them if I could. The seriousness of the charges before this court cannot be overstated. The accused is being held and charged with the malice murder of 2 people. These were intentional violent acts that were permanently destroying our family. Granting bond in a case of this magnitude would undermine the gravity of these crimes and the devastating harm that she has already inflicted. Then they move to addressing the Ayala factors. We remain deeply concerned about flight risk. The defendant is facing the possibility of life-altering consequences if convicted. Given the severity of the charges, the incentive to flee is substantial. The immediate family has the resources which would enable her to flee. Her family maintains that she is innocent, and given her manipulative behavior, it is possible for her to flee. Once released, there would be no meaningful way to ensure the defendant remains within the jurisdiction or appears for future court proceedings, since family and close friends have homes outside of the state of Georgia. We are also gravely concerned about witness intimidation. This case relies on witnesses who must be able to cooperate freely and safely with law enforcement and with the court. Releasing the defendant creates a real and reasonable fear that witnesses could be intimidated, influenced, or discouraged from coming forward. Even indirect contact or perceived threats would be irreparably damaging to the case. Finally, and most urgently, we fear for our own safety. The loss that our family has suffered has traumatized us and left us vulnerable. The thought of the person accused of killing them being released into the community causes us constant anxiety and fear. Bond would not only endanger witnesses, it would also place our family under continued emotional distress and fear for our physical safety.
And there it is. The state lands a plane. She was a poor candidate then. She's a poor candidate now. Notice what didn't happen. No new bombshell. No dramatic twist. No sudden evidentiary collapse. In bond reconsideration hearings, momentum matters. If the defense can't show the landscape has changed, the judge's safest legal move is consistency. Courts don't like reversing themselves without cause.
The accused is being charged with 2 malice murder counts. These are horrific and violent crimes in which she is being accused. The defendant's second bond request. This is the defendant's second bond request, and nothing has changed that would justify reconsideration. The risks remain the same, if not greater, as the case moves forward and the consequences become more real. Our family would not be able to sleep in peace knowing that she is not in protective custody. Judge, it's the state's position that on August 19th of 2025, she was a poor candidate for bond, and that as I stand here before you today, she remains a poor candidate for bond, and bond should be denied as such.
Who made the statement?
That was crafted by Kim Bowling on behalf of the other family, the Brock family.
Who was that for? Who made the statement?
Kim Bowling.
No, that's the sister.
It is.
At the past hearing, we also had a brother testify. Is that right?
We did, Judge. We had sons. We had sons and her, and then a friend of the family as well, if I recall correctly. It's going back a little bit.
I believe it was her brother, stepbrother. Is that correct?
I think so, Judge.
Is that right?
That's correct, Your Honor.
And he was not in favor at that time as well, correct?
Correct, Judge. There's significant numbers on this side as well.
And they lived together for a period of time, correct? The brother? That was my recollection, that he was in the house for a period of time. Is that not correct?
Not in recent memory, Judge. Not in recent history, is my understanding.
Anything else from the state?
Nothing else from the state, Judge.